Good afternoon, everyone. I hope you're doing good. I hope you had a great weekend. And so today we'll start with section 56, that is transfer and transmission of shares. But before I start with it, किसी को कोई doubt है हमने जो भी कर लिया है अभी तक उसमें? Any questions, any doubt in whatever we've done till now? Any questions in whatever we've covered till now? So are we good to start with the new section, section 56? Till now, we have understood what are shares, what are different types of share capital. We've also understood what are different ways of calling equity shares with differential voting rights. What are the rules which have to be complied with whenever equity shares with differential voting rights are issued? How issue of shares at premium happens. There's a prohibition on issue of shares at discount, but there are exceptional situations. We've understood what sweat equity shares are. So can someone tell me what sweat equity shares are? Can someone tell me what sweat equity shares are? किसको इशू किए जाते हैं sweat equity shares? Am I not audible? See, if you aren't responding to my questions, I am not starting with today's session. At least let me know if I'm audible or not. Okay, so sweat equity shares are shares issued to directors or employee at a discount or for consideration other than cash. Correct. So today we'll start with section 56. Section 56 talks about transfer and transmission of shares. So let's now understand what transfer and transmission of shares mean. So these two terms, transfer and transmission, both of them mean different things. There are different meanings to both of them. जब हम ट्रांसफर की बात करते हैं तब क्या होता है? Let's understand this with help of an example. Now say there's a person, Mr. Karan, and Karan has 100 shares in a company XY Limited. So Karan के पास क्या है? Karan के पास 100 shares है of XY Limited. Now Karan, he is selling these shares to another person, Karthik. So what is happening here? Karan has 100 shares in XY Limited and Karan is selling these shares. He's transferring these shares to another person, Mr. Karthik. So when we talk of transfer में क्या हो रहा है? Transfer is nothing but a normal sale. Transfer में क्या हो रहा है? A transfer is nothing but a normal sale. Now when we talk of sale, the one essential element of sale which comes up is consideration. So which means कि जब करंट कार्तिक को अपने सेल्स शेयर्स सेल करेगा तो he will demand something in return from Karthik. He'll take something in return from Karthik. He'll definitely not transfer his shares for free. जब आप say for example आपके पास रिलायंस इंडस्ट्रीज लिमिटेड के 50 शेयर्स हैं, अभी आप ये शेयर्स किसी और को बेच रहे हो, आप फ्री में बेच दोगे रिलायंस इंडस्ट्रीज लिमिटेड के 50 शेयर्स टू समवन, भले ही फ्रेंड ही क्यों ना या रिलेटिव ही क्यों ना? Will you sell the shares which you have for free? क्या आप अपने शेयर्स फ्री में बेच दोगे किसी को भी? At least say yes or no. Definitely not. You would not sell your shares for free to any person. So similarly, यहाँ पे भी when Karan he's selling his shares to Karthik, he will definitely take some amount, and that amount will be called as consideration. So ये जो arrangement है इसको बोलते हैं transfer. So जब हम transfer की बात कर रहे हैं, we are referring to a normal sale which is happening, normal sale of shares wherein one person is transferring his shares to some other person. But जब हम transmission की बात कर रहे हैं, transmission होता है 3 situations में. When we talk of transmission, transmission happens in 3 cases. First is in case of death of a person. Say Karan के पास 100 shares है XY Limited के, and now Karan has died. Now Karan की death होने पर ये shares किसके पास जाएंगे? ये shares जाएंगे Karan के legal heirs के पास or his nominee. The second situation wherein transmission happens is in case of insolvency of a person. What does insolvency mean? What does insolvency stand for? What does insolvency stand for? Insolvency का मतलब क्या है? Look, I am not speaking to myself here. So if I'm asking a question to you, I want you to respond and give answer. I'm sure you all must be knowing insolvency का मतलब क्या है, what insolvency means. If I'm not getting any answer, I'm not moving ahead. So insolvency is a situation wherein a person is not in a position to pay off his liabilities. So the second situation wherein transmission of shares happen is in case of insolvency. So insolvency के केस में shares किसको transmit हो जाएंगे? Insolvency के केस में shares transmit हो जाएगी to a person called as official receiver or official assignee. हु इज ऑफिशियल रिसीवर या ऑफिशियल असाइनी? जैसे कंपनी के लिक्विडेशन के केस में एक ऑफिशियल लिक्विडेटर अपॉइंट होता है, वैसे व्हेनेवर a person is declared as an insolvent, a person is appointed by the court who takes care of this insolvency procedure of selling the assets and paying off the liabilities using the proceeds of the asset. That person is called as an official receiver or an official assignee. He is appointed by the court. So insolvency के case में the shares will be transmitted to either the official receiver or the official assignee. And the third situation is in case a person turns lunatic. Who is a lunatic? I'm sure ये आप लोगों ने पढ़ा है. You all know who lunatic is. Can someone tell me who is a lunatic, or what does lunatic mean? A person of unsound mind, a person who is not in a position to understand things and make a rational decision. So the third situation wherein transmission of shares would happen is in a situation where a person turns lunatic. और इस situation में shares किसके पास जाएंगे? इस situation में shares जाएंगे to an administrator. Administrator is basically a person who's taking care of that lunatic person and who's taking care of all the contracts with respect which have been made by that lunatic person. So when we talk of transfer and when we talk of transmission, ये दोनों ही completely different situations है. Transfer में there's an actual sale which is happening, and transmission happens in three situations: death, insolvency, or when a person turns a person of unsound mind, in case a person is in case a person becomes lunatic. So abhi section 56 क्या बोलता है about transfer and transmission of shares? Let's understand. So whenever you are transferring say shares, आपके पास कुछ shares है कंपनी में और आप वो shares transfer कर रहे हो. So two parties are involved. एक होता है transferer, दूसरा होता है transferee. Transferer is a person who is transferring his shares, and transferee is a person to whom the shares are transferred. Now, when we talk of transfer of shares, shares दो type के हो सकते हैं, physical form में हो सकते हैं या फिर dematerialized form में हो सकते हैं. अभी जब हम बात करते हैं about transfer of shares, so transfer के लिए सबसे पहले क्या बनना चाहिए? Transfer के लिए बनना चाहिए एक deed. Deed is nothing but an agreement. उसको हम बोलते हैं transfer deed. A transfer deed has to be made between the transferor and the transferee. So एक transfer deed बनती है between the transferor and the transferee whenever the transfer is taking place. और जब भी ट्रांसफर हो रहा है, it has to be informed to the company कि if a person is transferring his shares, that person has the responsibility to inform to the company that उसने अपने shares जो है वो किसी और को transfer कर दिए. अभी ये जो डॉक्यूमेंट है, जो ट्रांसफर डीड है, that transfer deed shall contain a few particulars, and this transfer deed is made in a separate form का नाम है SH4. Form SH4 is the form जिसमें transfer deed बनाई जाती है, and this transfer deed has to contain certain details. Now what are the details? So सबसे पहले तो this transfer document has to be properly dated, has to be in a proper form, that is SH4, and it should be properly stamped. अभी transfer deed जो बन रहा है वो एक normal document पे नहीं बनेगा, ये stamp paper पे बनेगा. एंड अगर आप स्टैम्प पेपर पे बना रहे हो, एक सिर्फ ऐसे से फॉर एग्जांपल आपने एक वाइट प्लेन पेज ले लिया और उस प्लेन पेज पे यू रिटन ऑल द डिटेल्स about the transfer, who's transferor, who's transferee, and number of shares which are being transferred. Now that document will have no relevance. Whenever you're making a transfer deed, that transfer deed has to be on a stamp paper. और जब भी आप stamp paper पे कुछ भी बना रहे हो तो आपको stamp duty pay करना पड़ेगा. So whenever making this instrument of transfers, that is transfer deed, it has to be in a proper form. It has to be dated, proper date लिखा होना चाहिए उस पे, also properly stamped होना चाहिए. इसके अलावा one very important thing is that it should be signed by both transferor and transferee. दोनों का signature होना चाहिए. Not only the transferor, but the signature of transferee shall also be there on this transfer document. So signature of both transferor and transferee shall be present on this transfer document or the transfer deed. Apart from it, और क्या details रहेंगे? इस transfer document में transferee के details देना पड़ेगा. Name of the transferee, to whom the shares are being transferred, the address of the transferee, and occupation of the transferee. ये तीनों डिटेल्स क्लियरली मेंशन किए जाने चाहिए इन द ट्रांसफर डीड. सो व्हाट आर द डिटेल्स वी हैव अंडरस्टूड टिल नाउ? ट्रांसफर डीड shall be dated, stamped, it has to be signed, shall contain the details of name, address and occupation of the transferee. ठीक है, ये डिटेल्स होने चाहिए ऑन द ट्रांसफर डीड, एंड दिस डॉक्यूमेंट शैल बी डिलीवर्ड टू द कंपनी इन 60 days ऑफ ट्रांसफर. सो ट्रांसफर के 60 days में ये डॉक्यूमेंट जो है कंपनी को डिलीवर कर देना चाहिए. नाउ हु विल डिलीवर? क्वेश्चन आएगा, हु विल डिलीवर दिस ट्रांसफर डॉक्यूमेंट? इज इट द ट्रांसफरर who will deliver the transfer document, or is it the transferee who will deliver the transfer document? So the answer is कोई भी कर सकता है. It can be given, it can be delivered to the company either by the transferor or the transferee. दोनों में से कोई भी ये डॉक्यूमेंट कंपनी के साथ फाइल कर सकता है. However, there's one more thing which has to be understood here, and that is अभी we are talking of physical shares being transferred. Okay, so physical shares transfer होता है तो एक proof होता है कि आपके पास share allot हुआ है आपको. What is that proof? What is the document which shows your title to the share? What is the document which shows the your title to the share? Share certificate, correct. So share certificate भी आपको attach करना पड़ेगा along with the transfer deed. से अगर शेयर सर्टिफिकेट आया नहीं है, शेयर सर्टिफिकेट अलॉट नहीं किया गया है अभी तक, यू हैवंट रिसीव्ड द शेयर सर्टिफिकेट, देन व्हाट? देन इन सच सिचुएशन लेटर ऑफ अलॉटमेंट भी आप अटैच कर सकते हो. लेटर ऑफ अलॉटमेंट इज बेसिकली अ प्रूफ दैट द शेयर have been allotted to a particular person. So a share certificate, this also has to be attached whenever this transfer is happening. So transfer के केस में share certificate भी attach किया जाना चाहिए. The share certificate has to be attached to the transfer document. So अभी तक what did we understand? We have understood what that whenever transfer of shares is happening, the whenever transfer of shares is happening, in that situation, either the transferor or the transferee, they have to file this transfer deed in form ACH4 with the company. The details to be stated in the transfer deed are as follows. मतलब dated होना चाहिए, stamped होना चाहिए, signed होना चाहिए, name, address, occupation of transferee लिखा होना चाहिए उसमें, share certificate attached होना चाहिए उसके साथ, and all of these things shall be clearly stated in the transfer document. इतना समझ में आया? Are you all clear with this? Yes, okay. So let's now have a look at section 56. उसके बाद में हम ट्रांसमिशन की बात करेंगे, and then we'll go to DMAT form. Sorry, I'm sorry, I'm not well, so sorry for my voice. Okay. So section 56 says a company shall not register the transfer of the company of securities of the company unless a proper instrument of transfer in form ACH4 is filed with the company, which is duly stamped, dated and executed. Executed matlab signed by or on behalf of the transferor and the transferee. So जो भी requirements हमने देखे थे, right now all those things have been stated here. It should also specify the name, address and occupation of the transferee has to be delivered to the company by transferor or transferee within 60 days from date of execution. So 60 days के अंदर ये document जो है वो deliver कर देना चाहिए transferor या फिर transferee ने to the company. Sorry. And within 60 days, this document has to be transferred, has to be delivered to the company along with the certificate or letter of allotment. Certificate मतलब share certificate or the letter of allotment. However, अगर DMAT form में हो रहा है ना, if you are holding shares in dematerialized form, then all of this इज नॉट रिक्वायर्ड. डीमैट फॉर्म में अगर आप होल्ड कर रहे हो सिक्योरिटीज को तो इतना फॉर्मेलिटी करने की कोई जरूरत नहीं होती है, बिकॉज उस सिचुएशन में बोथ द पर्सन दे आर रजिस्टर्ड विद द डिपॉजिटरीज एंड द कंपनी विल डायरेक्टली इन्फॉर्म अबाउट द ट्रांसफर टू द डिपॉजिटरीज, और वो ट्रांसफर जो है वो रजिस्टर हो जाएगा. सो ऑल ऑफ दिस फॉर्मेलिटी इज टू बी कंप्लाइड विद ओनली इन सिचुएशन जहां पे फिजिकली आप शेयर्स होल्ड कर रहे हो. Nowadays all of this is not done because say if you are into trading or if you've done trading, so सेल आप करते हो इमीडिएट सेल हो जाता है, बाय आप करते हो इमीडिएट बाय हो जाता है. आपको कंपनी को ऐसे डॉक्यूमेंट फाइल करके बताना नहीं पड़ता है कि आई हैव सोल्ड द शेयर्स और आई हैव परचेज्ड द शेयर्स. ऐसा कुछ इंटीमेशन देने की जरूरत नहीं होती. ओके, नाउ लेट्स टॉक ऑफ समथिंग एल्स. से फॉर एग्जांपल मेरे पास 100 shares है. I have 100 shares of Infosys Limited. Okay, I have 100 shares of Infosys Limited, and these 100 shares are partly paid up. Say the price of each share is rupees 100, but out of rupees 100 I have paid 70 rupees on the shares. Remaining 30 जो है वो unpaid है अभी भी. So 30 rupees is unpaid. Okay, so 100 shares of Infosys, I have 100 shares of Infosys which are partly paid. Now I have transferred these 100 shares of Infosys to my friend, say Sonali. मेरी एक फ्रेंड है सोनाली और उसको मैंने ये 100 shares ट्रांसफर किए, बट these shares are partly paid up. फुल्ली पेड अप होते तो कोई प्रॉब्लम नहीं होता, बट यहाँ पे मैंने पार्टली पेड शेयर्स जो है वो ट्रांसफर किए. And I filed the transfer document with Infosys Limited. So whenever there is a transfer of partly paid shares, जब भी partly paid shares transfer हो रहा है and the company is being intimated by the transferor about transfer of these partly paid shares, तो situation में company जो है immediately transfer register नहीं करेगी. Company will first confirm from the transferee. So अभी क्या हुआ? I have filed the document, transfer document with Infosys Limited. Now Infosys Limited looks at the transfer document and they identify that these shares are partly paid up. Now since the shares are partly paid up, the company will first have to confirm with Sonali. Because क्या हो जाएगा बाद में से सोनाली बोल देगी कि नहीं नहीं शेयर्स तो एक्चुअली अश्लेषा के थे एंड शी डिड नॉट पे द एंटायर अमाउंट एंड शी हैज ट्रांसफर्ड द शेयर्स टू मी. सो बीइंग अ ट्रांसफरी ऑफ द शेयर्स मैं आई विल नॉट पे द रिमेनिंग 30 rupees. व्हाट इफ सोनाली डज समथिंग लाइक दिस? सो इसीलिए कंपनी के लिए बहुत ज्यादा इंपॉर्टेंट है कि वो जो ट्रांसफरी है उससे कंफर्मेशन ले ले कि यू नो द शेयर्स आर पार्टली पेड अप एंड यू विल पे द अमाउंट. जब भी हम कॉल करेंगे तब आप अमाउंट जो है वो हमको पे कर दोगे. सो इसीलिए whenever there is a transfer of partly paid shares, the company will then issue a notice to the transferee stating that ऐसा हमने transfer document receive किया है and you please give us a no objection that you have no objection with this transfer. आप हमको एक NOC दो कि ये transfer से आपको कोई objection नहीं है. And ये NOC देने के लिए the transferee has 2 weeks. ये NOC देने के लिए the transferee has got 2 weeks. Now 2 हफ्ते बाद 2 situations हो सकते हैं, 2 नहीं 3 situations हो सकते हैं. एक तो होगा transferee would accept that yes the transfer is valid and I am a party to this transfer and I have no problem, I'll pay the amount. Second चीज हो सकता है the transferee would decline, नहीं बोल देगी कि नहीं ये transfer valid नहीं. थर्ड चीज क्या हो सकता है? no response at all. After 2 weeks or within those 2 weeks, there could be 3 situations which may arise. One is the transferee would accept that yes, the transfer is a valid transfer. Second is the transferee would decline. And the third situation could be जब transferee कुछ respond ही नहीं करता तब फिर क्या? Accept कर लिया तो फिर company will register the transfer. Decline कर दिया, company will not register the transfer. But what if there is no response from the transferee? What do you think will happen? Transferee did not respond to the company's notice with the no objection. So what do you think will happen? Company register करेगी transfer या फिर नहीं register करेगी? What do you think? Not register? But the situation here is different. If the transferee does not respond, तो company transferee के silence को acceptance मान देगी and the transfer will be registered. If the transferee does not respond, transfer register हो जाएगा. Okay. So this is what happens in case partly paid shares are transferred. Because company बोलेगी हमने आपको 2 weeks दिए थे to respond. If you had any problem, if you had any objection, you should have told us within those 2 weeks. And since you have not responded, हम लोग ये जो transfer है इसको हम register कर रहे हैं. We are treating this as a valid transfer and registering it. So let's have a look at transfer of partly paid shares. So where an application for transfer of partly paid shares is made by transferor. See, अगर transferee खुद ही application कर रहा है ना of partly paid shares, then there is no objection. या in that situation, the company wouldn't ask the transferee again. But when the application is being made by transferor, उस situation में company को double confirmation की जरूरत रहेगी, and उस situation में company will send a notice to the transferee. So in that situation, company shall give a notice of such application in form ACH5 to the transferee, and the transferee gives no objection to the transfer within 2 weeks from the date of receipt of this notice. So situation means the company will register the transfer. समझ में आया? Transfer of partly paid shares. Yes. Now what if the instrument of transfer is lost या फिर late deliver होता है? So what was the time limit for delivery of instrument of transfer? 60 days. अभी क्या हुआ? या तो ये इंस्ट्रूमेंट गुम गया या फिर delayed, there's a delay in delivery. Delay in delivery मतलब late पहुंचा, after 60 days पहुंचा. गुम गया मतलब what could be the situation जहाँ पे गुम गया? It could be a case wherein, say for example, I posted the letter of transfer. Now that I posted the letter of transfer, वो पोस्ट में ही कहीं गुम गया, वो पोस्ट में ही कहीं गुम गया and it did not reach the company at all. और it could be a situation कि मेरा पोस्ट जो है वो पहुंचा बहुत late because of some bad weather conditions or something, and 60 days के beyond हो गया for the letter to reach. Then in that situation, what will happen? उस situation में transfer कैसे register होगा, transfer register होगा भी या नहीं register होगा? Let's understand. So what do you think? ऐसे situation में transfer register होगा कि नहीं होगा? नहीं होगा. Okay, why do you say nahi hoga or the transfer will not be registered? Because it has not reached yet. Okay. So इस situation में क्या होगा रे? इस situation में क्या होगा? इस situation में the board will decide what to do. The board मतलब the board of directors, they will decide what to do in case the transfer instrument is lost or in case there's a delay in delivery of transfer instrument. उस situation में the transfer would be registered. There is a possibility that the transfer may be registered, but on such terms that the board of directors would deem fit or as they would think fit. और ऐसे ही नहीं दे देंगे वो लोग transfer, they will not register transfer just like this, but you will have to sign an indemnity bond. एक indemnity bond sign करना पड़ेगा stating that ये ट्रांसफर एक्चुअली हुआ है. जैसे डुप्लीकेट शेयर सर्टिफिकेट इशू करते वक्त इंडेमनिटी बॉन्ड साइन होता है, वैसे ही यहाँ पे. नाउ से फॉर एग्जांपल, देयर इज अ पर्सन मिस्टर राज, एंड मिस्टर राज कंपनी के पास जाके बोलता है, से ही गोज टू अ कंपनी एक्स लिमिटेड एंड ही टेल्स द कंपनी कि मैंने ट्रांसफर से आई एम अ ट्रांसफरी ऑफ शेयर्स, अ पर्सन मिस्टर राजय हैज ट्रांसफर्ड हिज शेयर्स टू मी, बट हमारा जो ट्रांसफर डॉक्यूमेंट है, ट्रांसफर डीड है, वो ना कहीं गुम गया रास्ते में. वी डिड सेंड इट टू द कंपनी बट इट डिड नॉट रीच द कंपनी. सो राज गोज टू द कंपनी एंड टेल्स द कंपनी कि कंपनी आप प्लीज ये ट्रांसफर जो है वो आप रजिस्टर कर लीजिए एंड एंटर माई नेम इन द रजिस्टर ऑफ मेंबर्स एज द मेंबर ऑफ द कंपनी. नाउ इन द सिचुएशन, अभी कंपनी के पास प्रूफ तो है नहीं, कंपनी डज नॉट हैव द ट्रांसफर डॉक्यूमेंट. सो इन सच अ सिचुएशन कंपनी क्या करेगी? सो द बोर्ड, इफ दे थिंक ओके फाइन मिस्टर राज पे रिलाई किया जा सकता है, तो बोर्ड बोलेगी ओके फाइन, वी विल रजिस्टर दिस ट्रांसफर बट ऑन वन कंडीशन. नाउ व्हाट इज दैट कंडीशन? कंडीशन ये है कि आपको एक इंडेमनिटी बॉन्ड साइन करना पड़ेगा हमारे साथ. You will have to sign an indemnity bond with us, and you will sorry, and you will have to clearly state in that indemnity bond कि अगर फ्यूचर में कोई और आता है इस शेयर को क्लेम करने के लिए, तो अगर whatever losses, whatever damage the company will bear, you will have to pay the losses and damage to the company. So in a situation where the transfer instrument is lost or destroyed, the transfer may be registered if the board may think fit on signing of an indemnity bond. So ये indemnity bond के बिना transfer register नहीं होगा in a situation where the transfer instrument is lost or there's a delay in delivery of the transfer instrument. So यहाँ पे वही दिया गया है that the company may register transfer on such terms so as to indemnity as the board may think fit. So board, if they are of the opinion कि we can register this transfer, the transfer, yes, both transferor and transferee need to sign, but this is an exceptional situation जहाँ पे transfer deed जो है वो transfer deed गुम गई है या फिर there's a delayed delivery. 60 days के बाद पहुंचेगा तो they will have the transfer deed. But if it is lost, or if it is lost, then in that situation there wouldn't be any proof. So there are situations जहाँ पे लोग ना fraud करते हैं, forged document बनाते हैं. आगे will talk of forged transfer as well. So in that situation, अगर board को लगता है कि नहीं ये बंदा सही बोल रहा है and let's register the transfer, if they register the transfer, they'll also make this person sign an indemnity bond कि अगर हमको future में पता चला कि आपने हमसे झूठ बोला और ट्रांसफर रजिस्टर कराया, so you will have to compensate us for any loss which will happen to the company. So that is the reason why यहाँ पे indemnity bond आता है. Clear? Okay. So this was with respect to transfer of shares. Let's now talk of transmission. अभी ट्रांसमिशन जैसा मैंने बताया आपको 3 केसेस में होता है, डेथ, इंसॉल्वेंसी एंड व्हेन अ पर्सन इज lunatic. So डेथ के केस में they are transmitted to the legal representative, इंसॉल्वेंसी में ऑफिशियल रिसीवर और ऑफिशियल असाइनी, and in case lunatic हो जाता है तो the administrator who is appointed by court. So they will be the people to whom the transfer will happen. अभी say for example there was a person Mr. Rahul, and Mr. Rahul held say 500 shares in Reliance Industries Limited. राहुल के पास 500 shares थे of Reliance Industries Limited और Mr. Rahul has now died. Mr. Rahul मर गया. अभी in this situation, who has the right to receive the shares? Transmission होके shares किसके पास जाएंगे? ट्रांसमिशन होके शेयर्स वुड गो टू राहुल्स लीगल रिप्रेजेंटेटिव. नाउ ऐसे ही कंपनी ट्रांसमिट नहीं कर देगी शेयर्स. पहले द लीगल रिप्रेजेंटेटिव से राहुल का बेटा, राहुल सन इज से राजीव. So Rajiv, if he wants to claim these shares now, Rajiv will first have to send an intimation to the company. एक इंटिमेशन देना पड़ेगा कंपनी को ऑफ ट्रांसमिशन. सो इंटिमेशन ऑफ ट्रांसमिशन हैज टू बी सेंट टू द कंपनी. अभी कंपनी को थोड़ी पता चलेगा कि उसका मेंबर मर गया. You know, Reliance has thousands and thousands of shareholders. How will Reliance come to know कि एक से 50 शेयर्स होल्ड करने वाला शेयर होल्डर मर गया? उनको थोड़ी पता चलेगा. You will have to inform the company. And only then the company will register the transmission. So ये जो भी legal representative है, he'll have to file an intimation of transmission with the company. And सिर्फ, do you think the company will only believe the intimation of transmission? Will the company not require any proof? They will definitely require some proof. किस चीज का proof? सबसे पहले तो ये proof कि राहुल की actually death हुई है. Did Rahul actually die? So उसके लिए क्या होता है? Death certificate. And इसके अलावा क्या गारंटी है या क्या प्रूफ है दैट राजीव इज द पर्सन हु इज एंटाइटल्ड टू रिसीव राहुल्स शेयर? नाउ वेयर इज इट रिटन दैट यू आर हिज लीगल रिप्रेजेंटेटिव? कहाँ पे लिखा हुआ है ऐसा? हम आपकी बात कैसे मान लें? सो जब ये लीगल रिप्रेजेंटेटिव इंटीमेशन ऑफ ट्रांसमिशन दे रहा है, तो उस सिचुएशन में he'll have to prove कि the shareholder of the company is actually died. तो उसके लिए डेथ सर्टिफिकेट अटैच करना पड़ेगा. और क्या प्रूफ है दैट यू आर द पर्सन हु इज एंटाइटल्ड टू ट्रांसमिशन? तो उसके लिए क्या होता है? या तो विल होती है, राहुल्स विल, या फिर सक्सेशन डॉक्यूमेंट, डॉक्यूमेंट ऑफ सक्सेशन. और इफ देयर इज एनी नॉमिनेशन फॉर्म, सो वो नॉमिनेशन फॉर्म सबमिट करना पड़ेगा. सो in case of transmission, these are the things which happen. The person, the transferee, he'll have to intimate the company about the transmission and also give certain proofs that yes, I am the person who is entitled to receive the shares upon transmission and I am actually entitled to receive it. So this is what happens in case of transmission. So transmission के case में क्या है? The company shall register an intimation of transmission of any right to securities received by it from any person to whom such right has been transmitted. So whoever has this right will intimate the company, and on the basis of this intimation of transmission, the company will register the transmission. इतना समझ में आया? Have you all understood what happens in case of transfer and what happens in case of transmission? Any doubt so far? Clear? Okay. So before we move ahead, I wanted to share one thing with you. So what would be the time period for delivery of certificates? Certificate कौन से certificate की बात हो रही है? Share certificate की बात हो रही है. What would be the time period for delivery of certificate? तो कितने टाइम में share certificate issue हो जाना चाहिए? To the people who have subscribed to the securities in memorandum, so 2 months from the date of incorporation. So date of incorporation के 2 महीने में share certificate issue हो जाना चाहिए to the people who have subscribed to the memorandum. In case of allotment, 2 months from the date of allotment. किसी को allotment हुआ है shares का, so within 2 months from the date of allotment, the share certificate shall be delivered. In case of transfer or transmission, so 1 month from the date of receipt of transfer instrument, that is transfer deed. And debentures का allotment, debenture का certificate has to be issued within 6 months from the date of allotment. So these are different time spans within which the share certificate shall be issued for under different conditions. Now, let's take another example. Rahul or राजीव का ही कंटिन्यू करते हैं। So in this situation, Rahul dies, and Rajiv, being his legal representative, the shares will be transmitted to Rajiv. अभी इस situation में राजीव क्या करता है? राजीव wants to in turn sell these shares to a third person, say Ravi. राजीव को क्या करना है? ये शेयर्स जो है राजीव को बेचना है टू अ थर्ड पर्सन, रवि। अभी इसके लिए दो चीजें कर सकता है राजीव। नंबर वन इज पहले ट्रांसमिशन करे सिक्योरिटी, ट्रांसमिशन करे शेयर्स का, get himself his name entered into the register of members of the company, and then sell the shares to Ravi and transfer document file करे with the company. So this is a procedure which can be followed by Rajiv, but don't you think ये बहुत लंबा हो जाएगा? पहले ट्रांसमिशन के लिए डॉक्यूमेंट फाइल करो, फिर ट्रांसफर के लिए डॉक्यूमेंट फाइल करो. Don't you think the procedure would be very long, very lengthy? Yes. So इस situation में ना एक चीज section 56 subsection 5 it basically says that if a transfer of security is made by the legal representative, if transfer of securities of a deceased person is made by his legal representative, even if the legal representative is not the holder of the securities, even if the legal representative is not holding the securities, the transfer should be valid as if the legal representative was the holder of the securities when the instrument of transfer is registered. मतलब क्या? इस सिचुएशन में राजीव ना डायरेक्ट ये ट्रांसफर कर सकता है और डायरेक्ट जो ट्रांसफर डॉक्यूमेंट है वो कंपनी के साथ फाइल किया जा सकता है, इंस्टेड ऑफ गेटिंग हिमसेल्फ फर्स्ट रजिस्टर्ड विद द कंपनी फिर ट्रांसफर करने की जगह. Even if Rajiv is directly making the transfer of shares to Ravi even before the transmission, that type of transfer would be a valid transfer, and it will be considered as if Rajiv was the actual holder of shares, though he is not the actual holder of shares because transmission register नहीं हुआ है. पर फिर भी ये situation में ये जो transfer राजीव कर रहा है, that transfer will be a valid transfer and it will be deemed as if Rajiv was the holder of shares at the time when the instrument of transfer was registered. So क्योंकि वो transmission और फिर transfer बहुत ही एक लंबा lengthy process हो जाता, इसी वजह से section 56 subsection 5 has got this provision which says that the legal representative of a deceased person can transfer his shares even in a situation wherein he is not the holder, and that transfer would be a valid transfer. And that is what this point talks of. So transfer of any securities or interest of deceased person by legal representative shall be valid as if he had been the holder at the time of execution of the instrument of transfer. ये point समझ में आया? Okay. So let's now talk of punishment for default. अगर कुछ भी default होता है under this section, what would be the punishment? Penalty for the company. Company 50,000. Officer in default 50,000. So when any depository or depository participant has transferred shares with an intention to defraud a person, shall be liable under 447. Depository will come into picture in a situation where there is transfer of dematerialized share. So अगर dematerialized फॉर्म के सिक्योरिटीज का ट्रांसफर हो रहा है, उस सिचुएशन में द कंपनी विल हैव टू इन्फॉर्म द डिपॉजिटरी ऑफ सच ट्रांसफर एंड सच ट्रांसफर शैल बी रजिस्टर्ड बाय द डिपॉजिटरी. पर अगर कोई भी डिपॉजिटरी इज रजिस्टरिंग अ ट्रांसफर विद एन इंटेंशन टू डीफ्रॉड, मतलब फ्रॉड के इंटेंशन से ट्रांसफर कोई रजिस्टर कर रहा है डिपॉजिटरी, देन इन दैट सिचुएशन the depository and the depository participants, they would be liable under section 447 of the Companies Act. 447 talks about punishment for fraud. So let's now talk about forged transfer. I'm sure you all must be knowing the meaning of forgery. Forgery का मतलब पता है? अगर नहीं बोल रहा है कोई, इसका मतलब वो बहुत ही ज्यादा अच्छा बच्चा है. Forgery means what? Illegal signature. Basically copying someone's signature and stating कि ये सही signature है. So say in a situation the transferor's signature on the transfer document are forged. ट्रांसफरर के जो सिग्नेचर है वो फोर्स्ड है, मतलब ट्रांसफरी ने खुद ही ट्रांसफरर के सिग्नेचर कर लिए. से फॉर एग्जांपल देयर इज अ पर्सन मिस्टर करण एंड करण का बेटा है आदि. करण होल्ड्स 500 shares in TCS. करण के पास TCS के 500 shares है. आदि knows about it and आदि के मन में लालच है. Yes, he is Karan's son, but still he says कि यार dad has these 500 shares और ऐसे तो वो ट्रांसफर कर नहीं रहे मुझे, so मुझे ही कुछ करना पड़ेगा जिससे I get these shares registered in my name. So what Adi does is, Adi knows कि शेयर ट्रांसफर के क्या क्या फॉर्मेलिटीज होते हैं. So what Adi does is, आदि ट्रांसफर डॉक्यूमेंट पे करण के सिग्नेचर्स फोर्ज कर लेता है. He forges Karan's signature. आदि since he was a notorious kid school time में भी, तो उसने बहुत प्रैक्टिस की है करण का सिग्नेचर करने की, तो उसको करण का सिग्नेचर बहुत अच्छे से करते आता है. So on the transfer document, आदि forges Karan's signature और वो ट्रांसफर डॉक्यूमेंट कंपनी को सबमिट कर देता है. अभी हमने तो समझा है द ट्रांसफर डॉक्यूमेंट कैन ईदर बी सबमिटेड बाय द ट्रांसफरर और द ट्रांसफरी. और ऐसे सिचुएशन में जहां पे डीड कंप्लीट है, साइंड है, कंपनी को भी डाउट नहीं जाएगा एंड कंपनी विल रजिस्टर द ट्रांसफर. बट डू यू थिंक ये ट्रांसफर वैलिड है? डू यू थिंक दिस टाइप ऑफ ट्रांसफर शुड बी वैलिड? नो, डेफिनेटली नॉट. दिस टाइप ऑफ ट्रांसफर कैन नॉट बी वैलिड एट ऑल ना. मतलब फोर्जरी करके कोई ट्रांसफर करवा रहा है शेयर्स, तो this type of transfer is not a valid transfer. So forced transfer जब भी होता है, whenever there is any forced transfer which is happening, it is void ab initio. What does void ab initio mean? Am I not audible? Is it fine? Am I audible now? Am I audible now? I think the problem is fixed. Mahima, if you could please respond. Am I audible now? Okay. So I was saying the forced transfer is void ab initio. I was asking you what is the meaning of void ab initio. So it is void since very beginning, void since its inception. So forced transfer अगर register हो भी गया, so यहाँ पे हमारे example में आदि he has filed this document with TCS transfer deed and आदि का नाम भी register of members में आ गया है. एंड से बाद में करण जाता है कंपनी के पास एंड कंपनी को बोलता है रिस्टोर माय नेम इन द रजिस्टर ऑफ मेंबर, ये ट्रांसफर वैलिड ट्रांसफर नहीं था, इट वाज फोर्ज्ड, ऐसा फोर्जरी हुआ था. So in that situation, the company will have to restore Karan's name in the register. So forced transfer पहले से ही since its beginning it is void, it has no validity at all. Now say let's add something to this example. अभी क्या आदि का नाम रजिस्टर हो गया in the register of members, Adi's name has been entered into in the register of members on the basis of this forced transfer. And Adi further makes the sale of Adi makes a further sale of shares to his friend Simi. So Adi ने क्या किया? Forced transfer किया और आगे ये शेयर्स जो है अपनी फ्रेंड को बेच दिए. He sold the shares to Simi. And Simi, she is an innocent buyer. She has purchased the shares from Adi in good faith. She is not aware of any such wrongdoing which Adi has done. She is not aware of any such forced transfer. She has bought the shares in good faith. And since ये transfer हुआ तो फिर अभी सिमी का नाम has been entered into the register of members. Now meanwhile Karan now wants to sell his shares and Karan कंपनी के पास जाता है and एक ट्रांसफर डॉक्यूमेंट देता है कंपनी को. कंपनी करण को बोलती है कि ये शेयर्स तो आपने पहले ही बेच दिए हैं, अभी आप शेयर्स कैसे बेच सकते हो? तो करण बोलता है नॉट पॉसिबल एट ऑल, आई हैवंट सोल्ड दी शेयर्स एट ऑल, मैंने तो ये शेयर्स बेचे ही नहीं है. तो कंपनी बोलती है सी लुक हियर, यहाँ पे देखो आप हमारे रजिस्टर में आपने किसी मिस्टर आदि को शेयर्स बेचे थे एंड अभी नाउ ही हैज आल्सो सोल्ड द शेयर्स टू समवन एल्स, सो हाउ कैन यू कम नाउ? सो इस सिचुएशन में क्या होगा? आपको क्या लगता है क्या होगा? सिमी का नाम ही रहेगा रजिस्टर ऑफ मेंबर्स में या फिर द कंपनी विल हैव टू रिस्टोर द ओरिजिनल ओनर्स नेम इन द रजिस्टर ऑफ मेंबर्स? What do you think will happen? Original owner? Yes, the company will have to restore the original owner's name in the register of members. The meaning being very simple. Have you heard of this maxim? ये मैक्सिम कहीं पढ़ा है, सुना है, याद आ रहा है? Nemo dat quod non habet. कुछ याद आ रहा है ये पढ़ के? सेल ऑफ गुड्स एक्ट. क्या याद है? यू टोल्ड यस, तो अभी अभी मुझे बताएगा उसको क्या याद आ रहा है. सो अगर सेल ऑफ गुड्स एक्ट थोड़ा बहुत याद होगा तो वहां पे मैक्सिम आता है एंड इट सेज दैट नो वन कैन गिव व्हाट ही हैज नॉट गॉट.
Ma'am, like they will say that if the title is not there for that person, he cannot sell the goods like that.
Correct. So if you do not have the title to goods, so you cannot sell the goods. So similarly यहाँ पे, did Adi have a good title to the shares? No, he did not. It was a forced transfer. And that is the reason why here Simi का position भी जो होगा वो she'll not get a right in the share, she'll not become the rightful owner because since Adi was not the owner of the shares, Adi can also not transfer ownership to Simi. So इस situation में the company will have to restore the name of Karan in the register of members. अभी इस situation में Simi की तो कोई गलती थी ही नहीं. Simi was an innocent buyer. She purchased the shares in good faith. So Simi can claim damages from the company. Simi company से damages claim कर सकती है. However, जो भी damages company Simi को pay कर रही है, company can in turn recover those damages from Adi जिसने forged transfers किया था actually. So this is the entire story behind forged transfer, what happens in case of a forged transfer. Is that clear? No punishment, ऐसा कुछ नहीं है. He'll have to pay the damages and other stuff to the company. He'll have to indemnify the company against whatever wrong acts he's done. So if the transferee of the forged transfer transfers the shares to another buyer who does not know about the forgery, and the company registered the transfers in the name of new buyer, then in that situation, company cannot deny the ownership rights of the new buyer, but it can also not deny the ownership rights of the original shareholder, and therefore the company will have to restore the name of the original shareholder in the register of members. The company shall compensate the new genuine buyer. New genuine buyer in our example was Simi. Original shareholder हमारे example में था Karan. So the company shall get itself indemnified by the first transferee who used forged instrument. मतलब ये कौन? मिस्टर आदि. ठीक है. So क्या होगा अगर forged transfer के basis पे जिस transferee ने document forge किया था and he got the shares transferred in his own name, if he's making a further sale and that is a genuine buyer, and that genuine buyer has to be compensated by the company. However, whatever compensation, whatever damages the company is paying to this genuine buyer, the company can recover all of this from the transferee who had registered this forged instrument of transfer. Clear है? Forged transfer समझ में आया? So this was with respect to transfer and transmission of securities. समझ में आया? कोई doubt है? Sorry. Yes. So let's now start with another section. ये बहुत ही simple सा section है. Let's do it. So section 57, it talks about punishment for personation of shareholder. Now, what do you understand by this term personation? What does personation stand for? Act as another person or represent yourself to be someone who you're not. So it is basically cheating someone. ऐसे अपने आप को ऐसे represent करना कि आप कोई XYZ person हो जबकि आप वो XYZ person नहीं हो. So that is called as personation. So section 57 says if a person deceitfully personate, deceitfully basically means with an intention to cheat, जानबूझकर. If any person deceitfully personates as the owner of any security or interest in the company, or owner of any share, warrant, or coupon issued in pursuance of the Companies Act, he shall be punishable with imprisonment not less than 1 year, which may extend to 3 years, and fine not less than 1 lakh, which may extend to 5 lakh. So, अगर कोई person जानबूझकर he is representing that he is the shareholder in a company wherein he is actually not, and उसके basis पे कुछ हुआ है, then in that situation, such person he shall be punishable with imprisonment, minimum 1 साल, maximum 3 years, and also fine, which should not be less than 1 lakh. Minimum fine is 1 lakh, which may extend to 5 lakhs. So this is a punishment to a person who impersonates to be someone who is not. He impersonates a shareholder of the company. So anyone who's doing such an act, he will be punished. Usko punishment milega. Clear hai? It's a very general section. So ये section generally they do not ask it individually in exam, but rather ये किसी और section के साथ mix करके club करके वैसे पूछ सकते हैं. Coupon means bonds या फिर interest. ठीक है. So let's start with section 58 and understand what section 58 talks of. Now section 58 बोलता है what will happen in a situation जहाँ पे company refuses to register the transfer or transmission. Now here we'll look at case from point of view of a private company and then from point of view of a public company. तो क्या होता है, प्राइवेट कंपनी अगर रेफ्यूज कर देते हैं या पब्लिक कंपनी रेफ्यूज करते हैं. So in both the situations, whether you are transferring shares of a private company or a public company, सबसे पहला step 1 तो होगा transfer deed has to be submitted to the company. That is form SH4 आपने कंपनी के साथ फाइल कर दिया, ट्रांसफर इंस्ट्रूमेंट. नाउ कंपनी के पास राइट होता है उस ट्रांसफर को रजिस्टर करने का या फिर रेफ्यूज टू रजिस्टर करने का. तो उस सिचुएशन में क्या होगा? नाउ से private company, let's first understand the case from a private company's point of view and then go to public company. So private company, say I had shares of a private company and I transferred the shares to someone, I sold the shares to someone, I've also filed a transfer deed with the company. But company मेरा transfer deed देख के refuse कर देता है to register the transfer for some reason. So whenever a private company is refusing to register a transfer, it has to send this notice of refusal to whom? To both the transferor and the transferee within 30 days. 30 days कब से? जब से वो ट्रांसफर डॉक्यूमेंट कंपनी के पास गया तब से. So private company के केस में the company shall send a notice of refusal to the transferor and the transferee or to person who is giving intimation. This is in case of transmission within 30 days from the date on which instrument of transfer or the intimation of such transmission was delivered to the company. So if the company is refusing to register the transfer, company को inform करना पड़ेगा मुझे भी और transferee को भी कि I am not registering this transfer. The company will have to clearly intimate both the transferor and the transferee that the company is not registering a particular transfer. And what is the time limit within which the company has to do it? Within 30 days from the date when the document of transfer or the intimation of transmission has been filed with the company, has been delivered to the company. अभी इसके बाद क्या होगा? इसके बाद राइट है ट्रांसफरी के पास, नॉट द ट्रांसफरर, ट्रांसफरी. अभी ट्रांसफरी के पास राइट है, क्या राइट है? ट्रांसफरी के पास राइट है that the transferee can make an appeal to the tribunal. Tribunal here means the National Company Law Tribunal. So कंपनी से रिलेटेड जो भी केसेस है ना वो सबसे पहले NCLT में जाते हैं, फिर उसके बाद कोर्ट्स में जाते हैं. सो ट्रांसफरी अभी नोटिस ऑफ रेफ्यूजल आ गया ट्रांसफरी के पास, तो ट्रांसफरी के पास अभी राइट है टू गो एंड मेक एन अपील अगेंस्ट दिस refusal of the company with the tribunal. Now this can be done by the transferee within 30 days from the date of receipt of notice of refusal. But what if the company has not given any notice of refusal at all and has not registered the transfer? उस situation में क्या? So उस situation में the transferee can make an appeal, file an appeal with the tribunal within 60 days from the date on which the information was communicated to the company. So the transferee may file an appeal with the tribunal against the refusal within 30 days of receipt of notice of refusal. तो अगर नोटिस ऑफ रिफ्यूजल रिसीव होता है तो 30 डेज में ट्रांसफरी जो है ट्रिब्यूनल के साथ अपील फाइल कर सकता है, या फिर अगर कंपनी ने नोटिस ऑफ रिफ्यूजल भेजा ही नहीं है, द कंपनी हैज नॉट सेंट द नोटिस ऑफ रिफ्यूजल एंड हैज आल्सो नॉट रजिस्टर्ड द ट्रांसफर, then in that situation within 60 days from the date on which instrument of transfer was delivered to the company. Effectively देखा जाए तो दोनों ही केस में 60 days ही आएगा. How is that so? नोटिस ऑफ रिफ्यूजल के लिए कंपनी के पास 30 days थे और यहाँ पे 30 days थे. द ट्रांसफरी हैड 30 days एंड ये 60 days जो है दिस इज इन अ सिचुएशन जहाँ पे नोटिस ऑफ रिफ्यूजल मिला ही नहीं. तो इफेक्टिवली इफ यू सी 60 days का टाइम स्पैन है, but there is a difference in both the situation. This is a case where notice of refusal has been received. And this is a case where notice is not received. Okay. So this is in a situation private company ने refuse किया है. Now what if public company has refused to register the transfer? उस situation में क्या time limits रहे? So public company के पास public company की situation में there's only a slight difference in the time limit. It is 60 days and 90 days which the person has. So public company के case में we know that securities in a public company they are freely transferable. Private company में तो भी restriction होता है, तो हम बोल सकते हैं कि प्राइवेट कंपनी ने रिफ्यूज किया होगा तो देयर शुड हैव बीन सम रीजन, बट इन अ पब्लिक कंपनी द शेयर्स आर फ्रीली ट्रांसफरेबल. तो पब्लिक कंपनी ऐसे ही किसी को रिफ्यूज नहीं कर सकता अनलेस एंड अंटिल देयर इज अ गुड रीजन. सो इफ अ पब्लिक कंपनी रिफ्यूजेस विदाउट सफिशिएंट कॉज, दे डू नॉट हैव अ कॉज बट फिर भी वो लोग रिफ्यूज कर, without sufficient cause to register transfer or transmission of securities within 30 days from the date of date on which the transfer instrument has been registered with the company, has been delivered to the company. तो situation में बस यहाँ पे change है इधर, the transferee may appeal the tribunal within 60 days from notice of refusal, और अगर notice of refusal नहीं है तो within 90 days from the date of delivery of instrument of transfer. So यहाँ पे जहाँ पे 30 days and 60 days था, in case of public company it is 60 days and 90 days. That's the only difference. समझ में आया ये? Sorry. Is this much clear? ठीक है. So in a situation wherein a company refuses to register a transfer, in a situation where the company is not registering a transfer, the transferee can file an appeal with the tribunal. It is not the transferor, it is only the transferee who can file an appeal with the tribunal. Transferor नहीं करेगा, transferee के पास right है to file an appeal with the tribunal. अभी ट्रिब्यूनल के साथ अपील फाइल करने के बाद क्या होगा, जो भी ऑर्डर होगा ट्रिब्यूनल का वो दैट विल बी बाइंडिंग ऑन एवरीवन. नाउ वंस द अपील इज फाइल्ड विद द ट्रिब्यूनल, ट्रिब्यूनल में ईदर डिसमिस द अपील, अगर ट्रिब्यूनल को लगता है कि नहीं ये ऐसे ही फालतू का अपील कर रहे हैं एंड दिस ट्रांसफर इज नॉट, दिस इज नॉट समथिंग व्हिच शुड बी डिस्कस्ड इन द ट्रिब्यूनल, ट्रिब्यूनल कैन डिसमिस द अपील. या फिर if the tribunal takes the appeal into consideration, the tribunal will pass an order for transmission or transfer to be registered within 10 days, or rectification of register, and also direct the company to pay damages if any which the aggrieved party is suffering. Aggrieved party matlab the person who suffers because of the company not registering the transfer. So क्या करेगा tribunal? Tribunal can either dismiss the appeal, डिसमिस मतलब खारिज कर देगा, डिसमिस कर देगा, कंप्लीटली डिसमिस, या फिर द ट्रिब्यूनल विल पास एन ऑर्डर that the transfer or transmission shall be registered within 10 days, या फिर जो भी रेक्टिफिकेशन करना है इन द रजिस्टर ऑफ मेंबर, इट हैज टू बी डन बाय द कंपनी एज सून एज पॉसिबल. एंड if the aggrieved party has suffered any damages because of the Companies Act, the company shall pay damages to the aggrieved party. And in the situation, if the order of tribunal is not followed, तो उस situation में imprisonment होगा of not less than 1 year, which makes 10 to 3 years, and fine not less than 1 lakh, which makes 10 to 5 lakh rupees. ये समझ में आया? इतना clear है? So this is what section 58 talks of. Section 58 जो है, ये एक बार there was a question which was asked on this particular section in examination. It is a very easy section, very simple. You just do not have to mess up with the time span, time limits. Generally, what mistakes are made in this particular section is वो 30, 60, 60, 90. लोग भूल जाते हैं कहाँ पे 30 days है, कहाँ पे 60 days है और कहाँ पे 90 days है. So be very clear कि प्राइवेट कंपनी के केस में इट इज 30, 30 एंड 60. पब्लिक कंपनी के केस में इट इज 30, 60 एंड 90. ओवरऑल लिमिट प्राइवेट कंपनी के केस में 60 days है, पब्लिक कंपनी के केस में 90 days है. नाउ दैट विल हेल्प यू रिमेंबर थिंग्स फॉर अ लॉन्गर टाइम. एंड a direct question had come on, direct मतलब a case study had come exam में, but which was a very direct case study based on this particular section, and you will be able to answer it only if you know the provisions well. Okay. Before I start the other section, give me 2 minutes. Meanwhile, if you have any doubt in whatever we've discussed till now, please feel free to ask, because 59 के बाद we'll start with alteration of share capital, which is again a very 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 important section. So अगर कोई भी doubt है तो आप लोग अभी पूछ लो.
Ma'am,
Yes.
for private company and public company, notice should be sent within 30 days only, no, ma'am?
Yeah, the private company and the public company, if they are refusing to register the transfer, they'll have to send a notice within 30 days.
Okay, but after that 30, 60 and 60, 90.
Yeah, correct.
Okay.
60 is in a situation wherein the private company does not register the transfer and also does not send the notice of refusal.
Yes, ma'am, understood.
Yeah. So talking of section 59, which talks of rectification of the register of members. So 59 क्या बोलता है कि if the name of any person is without sufficient cause entered in the register of members, मतलब मेंबर नहीं है कंपनी का, फिर भी उसका नाम रजिस्टर ऑफ मेंबर में आ गया गलती से, आफ्टर हैविंग बीइंग एंटर्ड इज ओमिटेड देयरफ्रॉम, मतलब किसी का नाम एंटर किया इन द रजिस्टर ऑफ मेंबर बट लेटर ऑन हैज बीन ओमिटेड, or if a default is made or unnecessary delay takes place in entering in the register. So 3 situations. One is without sufficient cause someone's name has been entered into the register of members. Second is someone's name was entered but it was later on omitted without any reason. Third is a default has been made, there's an unnecessary delay in entering a person's name in the register of members. So situation में क्या हो? In that situation, an appeal can be made to the tribunal or to a competent court outside India. This is in a situation जहाँ पे member जो है he resides outside India. So, इंडिया में कोई है तो वो ट्रिब्यूनल को अपील करेगा, बट अगर कोई आउटसाइड इंडिया है, फॉरेन मेंबर है, तो they will have to file the appeal in the competent court outside India. Who can file this appeal? It can be made by the person aggrieved, मतलब who suffers because of his name not being entered into the register of members, yeah, any of these 3 reasons, any member of the company or the company. So the appeal can be filed either by the person who's aggrieved, that is who suffers, or by any member of the company, or by the company itself. They can file an appeal either with the tribunal or any competent court outside India in case of a foreign member. And the tribunal may, after hearing the parties to the appeal, they may either dismiss the appeal or order the transfer or transmission to be registered within 10 days of order, or direct the rectification of records and order company to pay damages which are sustained by the aggrieved party. So जो भी damages हुए हैं इन लोगों को उसका जो भी damages aggrieved party को हुए, the company will have to pay the damages to the aggrieved party. Is this clear? ये समझ में आया? Rectification of register. So basically, if there's any mistake which has happened, तो फिर an appeal can be filed with the tribunal. और tribunal का जो भी order होगा, tribunal can either pass an order कि जो भी transfer transmission है, it has to register, या फिर dismiss कर देगा if the appeal is not valid. या फिर the tribunal would say that the company should rectify its register as required, and also if any damages are sustained by the aggrieved party, the aggrieved party shall be paid those damages by the company. So that is how rectification of the register of members takes place under section 59. Clear? Take a break of 5 minutes and then we'll start with alteration of share capital. So sorry, I am not well. So take a break of 5 minutes. I'll be back. Meanwhile, if you have any doubts, you can drop in your doubts in the chat box. Okay, so any questions so far? Are you all back? Are you all there? So any questions, any doubts? If not, so let's start with alteration of share capital. So when we talk of alteration of share capital, we're basically going to talk of alteration of the capital clause of the company. So if you remember when we were doing alteration of clauses of memorandum, we did not cover alteration of capital clause there, और तब मैंने आपको बोला था कि section 61 जब आएगा तब हम इसको in detail discuss करेंगे कि कैसे होता है alteration of capital and what are the different ways as to how the capital is altered. So let's now understand. Alteration of share capital. Now, when we talk of alteration of capital, there are different ways as to how alteration of capital happens. सबसे पहला है increase in authorized share capital. The second is consolidation. Then there's something called as subdivision. Then the conversion of shares into stock and vice versa. And then finally, there's cancellation. So these are the different ways in which the share capital of a company is altered. So let's understand each one step by step, and let's take examples and understand all of them. Say there's a company Bluetech Limited. Now, Bluetech Limited's capital clause states that the authorized share capital of the company is divided into 1 lakh shares of rupees 10 each. तो ऑथराइज शेयर कैपिटल कितना हो गया इस कंपनी का? 10 lakhs. Yes. So this is the authorized share capital as stated in the capital clause of the company. Now, अभी कंपनी को लगता है कि 10 लाख रुपए will not be sufficient. 10 lakhs is not sufficient for the company to carry on its operations and कंपनी को ज्यादा पैसा लगेगा. So कंपनी सोचती है कि ये कैपिटल ऑथराइज शेयर कैपिटल जो है let's increase it from 10 lakhs to 15 lakhs. So in this situation there's an addition of rupees 5 lakh in the authorized share capital of the company. So यहाँ पे क्या हो रहा है? There's an alteration in the authorized share capital of the company. Increase in authorized share capital is not going to have any impact on the share capital which appears in the balance sheet. Paid up capital में कोई फर्क नहीं दिखेगा. Company has raised the entire amount of 10 lakh, but now company needs more money. Now that company needs more money, we know that authorized share capital is the maximum amount which the company can raise. अभी मैक्सिमम अमाउंट कंपनी ने इशू रेज कर लिया है, बट दैट अमाउंट इज नॉट सफिशिएंट और कंपनी को उस अमाउंट को बढ़ाना है. सो उस सिचुएशन में क्या करेगी कंपनी वांट्स टू इंक्रीज इट्स ऑथराइज्ड शेयर कैपिटल, इट वांट्स टू रेज मोर मनी. सो फॉर दैट इट विल फर्स्ट हैव टू इंक्रीज इट्स ऑथराइज्ड कैपिटल. So the first way in which the capital clause can be altered is by increasing the authorized share capital of the company by changing the amount of the authorized share capital of the company. अभी इसके लिए क्या करेगा, क्या लगेगा? We generally see कि हर situation में we say special resolution, special resolution, special resolution. However, यहाँ पे special resolution नहीं लगेगा. एक normal board resolution and then an ordinary resolution would be sufficient. So for alteration of increase for the purpose of increasing the authorized share capital of the company, यहाँ पे कंपनी को कोई स्पेशल रेजोल्यूशन पास करने की जरूरत नहीं है अलग से. ऑर्डिनरी रेजोल्यूशन would also do. So this is the first way in which there is a change in the capital of the company, share capital. So first क्या था, increase in authorized share capital. तो अभी authorized share capital 15 lakhs हो गया. And this change has to appear in the capital clause of the company because capital clause states the authorized share capital of the company. So यहाँ पे क्या हुआ है, there is an increase in the authorized share capital. Second चीज क्या बोला था मैंने आपको, second चीज बोला था consolidation. So currently the company has issued 1 lakh shares of rupees 10 each. ठीक है, अभी क्या हो रहा है, कंपनी बोलती है that what if I change this nominal value of the share. ये जो nominal value है ना, I'll change this from 10 rupees to 100 rupees. तो कंपनी बोलती है कि जिसके पास भी 10 शेयर्स है 10 रुपए के, उनके पास अभी एक शेयर होगा 100 रुपए का. कंपनी बोलती है that what if I give you one share worth rupees 100 instead of in place of your 10 shares of rupees 10. So यहाँ पे क्या हो रहा है, the amount is going from a smaller amount to a higher amount. Consolidation में the amount of the share is being changed from a smaller amount to a higher amount. So it is going to a larger amount from 10 rupees. अभी शेयर का वैल्यू हो रहा है 100 rupees. So यहाँ पे शेयर्स कम हो जाएंगे, अभी सिर्फ 10,000 शेयर्स रहेंगे. Yes or no? From 10 rupees, the value of share is going to 100. It is not increasing share capital. Your shares, the number of shares will decrease. In place of 10 shares, I am giving you one share of 100. You had 10 shares earlier of 10 rupees each, but now I'm giving you one share of 100 rupees each. You had 10 shares of 10 rupees each, and now I'm giving you one share which is equivalent to 100 rupees. The effect is only this, that the shares जो है कंपनी के वो अब कम हो गए. पहले 1 लाख शेयर्स थे, अभी शेयर्स कम हो गए. There is a consolidation which has happened. तो 10 शेयर्स मिला दिए हमने और एक शेयर बना दिया. तो अगर आपके पास 10 शेयर्स है कंपनी के, अभी आपके पास सिर्फ एक ही शेयर रहेगा, बट उसका वैल्यू 100 रुपीज रहेगा. Yes, 10 shares become 1. So यहाँ पे भी there is a change which is happening in the capital because of consolidation. We have merged 10 shares into one. So अभी now the company has 10,000 shares of 100 rupees each, right? अभी कंपनी के पास 10,000 shares है of 100 rupees each. Yes, so this is also a change in the capital of the company. This will not affect the paid up capital of the company. देखो paid up capital पे कोई impact नहीं रहेगा इसका, पर there is a change in the nominal value of the shares. There is a change in the number of shares, which will in turn have to be reflected in the capital clause of the company. Capital clause में इसका detail जाना चाहिए. So the second way in which alteration of capital happens is via consolidation. So going from a smaller amount to a higher amount. अभी third situation जो है, it is subdivision. Yes, in this situation also ordinary resolutions. Subdivision के केस में क्या होगा? In consolidation we have understood 1 lakh shares जो 10 rupees के थे उसको we have changed from 10 rupees to 100 rupees. Subdivision, the name itself suggests there is a division which is happening. Divide हो रहा है केस का. Yes, it is opposite. मतलब अभी कंपनी बोलता है आपके पास एक शेयर है 10 रुपए का, What if I give you 10 shares of 1 rupees each? तो यहाँ पे say the amount of share is now becoming 1 और यहाँ पे हो जाएंगे 10 lakh shares. So this is going from a higher amount to a lower amount. डिवाइड कर रही है कंपनी अपने शेयर्स को. कंसोलिडेशन में क्या था, कंपनी ने मिलाया था अपने शेयर्स को, इट मर्ज्ड इट्स शेयर्स इनटू हायर वैल्यू, एंड हियर द कंपनी इज डिवाइडिंग इट्स shares into share of a smaller value. So this is what happens in case of subdivision. So पहले क्या था, कंपनी के पास 1 lakh shares of 10 rupees each, and now the company is issuing 10 lakh shares of rupees 1 each. इतना समझ में आया? Subdivision तक क्लियर है? Any questions, any doubt? Clear? So these were the first 3 methods of alteration of share capital. The fourth one is conversion of share into stock. If you remember the first day when we started with this chapter, I told you what stock is. What is stock? What does a stock consist of? Group of shares, and it consists of fully paid up shares. Now say for example, I am a shareholder in the company. I have 5,000 shares of the company of rupees 100 each. मेरे पास 5,000 shares है of rupees 100 each. अभी now कंपनी क्या करती है, ये सारे shares बोलती है, कंपनी बोलती है that let's merge all the shares, let's bundle all the share, और वो बन जाएगा एक stock of 5 lakh. Company says let's bundle up all the shares so that it becomes a stock of 5 lakh. See, whenever we refer to a stock को जब भी refer करेंगे ना, stock को हमेशा एक lump sum amount में refer करते हैं. We do not refer to stock as bundle of so many shares. We refer to stock as a lump sum amount. And stock issue नहीं होता है. Shares are issued. Stock issue नहीं होता है. And it is also possible that the stock is reconverted back to shares. So conversion of shares into stock is also alteration of capital clause, alteration of capital of the company, and it is basically converting all the fully paid shares into stock. It is also possible कि ये stock में convert करने के बाद the stock is reconverted into shares. So whether it is conversion or reconversion, in both the situations, there is an alteration in the capital clause. There is a change in the capital clause. समझ में आई है? Conversion of shares into stock and stock back into shares. And finally, the last way in which alteration happens is cancellation of shares. Say for example, company ने issue किया कितने shares थे? 1 lakh shares of 10 each. कंपनी ने इशू किया पूरा 1 लाख शेयर ऑफ रुपीज 10 ईच, पूरा इशू किया, बट इसमें से सिर्फ 98,000 शेयर्स जो है वो सब्सक्राइब हुए. आउट ऑफ द टोटल इशू शेयर्स सिर्फ 98,000 सब्सक्राइब हुए, मतलब 2,000 shares were not subscribed at all. So what company does is company cancels these 2,000 shares. ये 2,000 shares जो इशू किए थे उनको company is cancelling. It is not reducing the share capital of the company. Company is only cancelling the shares which it had issued and which were not subscribed. So cancelling the shares will not lead to a reduction in the share capital. Rather, the company is only cancelling the shares which were not subscribed by the public. So these are the different ways in which a company, in which there's a change in the capital clause of the company. If you wish to just make a note of the example so that you remember जब भी आप पढ़ो कि एग्जैक्टली क्या हो रहा है सिचुएशन में, यू कैन मेक अ नोट ऑफ इट एंड डू लेट मी नो इफ यू आर मेकिंग अ नोट ऑफ इट. आई विल वेट, नहीं तो मैं आगे बढ़ती. आर यू मेकिंग अ नोट ऑफ इट? And let me know once you're done. You can take screenshot, you can do anything, whatever is convenient to you. Done? Yes, shares of one shareholder are converted into stock. जो भी fully paid up shares होते हैं एक शेयर होल्डर के, उसको एक साथ स्टॉक में कन्वर्ट करते हैं. ओके, ठीक है. So let's have a look at section 61. See, alteration of capital is possible only where a company has share capital. अगर एक ऐसी कंपनी है जहां पे शेयर कैपिटल है ही नहीं, say company limited by guarantee and not having share capital. So situation में alteration of capital clause does not come into picture because the company does not have capital at all. So only a company which has share capital, वहां पे ही alteration of capital, share capital is possible. So a limited company having share capital may alter its MOA in its general meeting to increase its authorized share capital, consolidate and divide all or any of its share capital into shares of a larger amount than its existing shares. So this is what happens in consolidation. However, इन सब चीजों के लिए ना कहीं कोई अप्रूवल की जरूरत नहीं है. If you remember when we were talking of alteration of clauses of memorandum, therein we have understood कहीं पे सेंट्रल गवर्नमेंट का अप्रूवल चाहिए, कहीं पे ट्रिब्यूनल का अप्रूवल चाहिए. हाउएवर व्हेन वी आर टॉकिंग ऑफ ऑल्टरेशन ऑफ कैपिटल क्लॉज ऑफ द कंपनी, approval of central government, tribunal and other authorities is not required except for one situation, and that is अगर consolidation की वजह से there is any change in the voting rights or there is any change in the voting percentage, तो फिर उस situation में tribunal का approval लगेगा. So this is the only situation जहाँ पे tribunal का approval लगेगा. If the consolidation of shares it leads to change in the voting percentage, तो फिर वहाँ पे tribunal का approval would be required. The next way of conversion is conversion of all or any of its fully paid up shares into stock, या फिर reconversion of stock into shares of any denomination, subdivision of shares into smaller amount than what is fixed by memorandum, then cancel the unsubscribed shares and thus diminish the amount of share capital. Cancellation is not reduction. See, cancellation हमने देखा है section 61 में. When we go to section 66, वहां पे we are going to specifically talk of reduction in share capital, which is completely different. ठीक है, so do not confuse with cancellation and reduction. Cancellation में it is only cancellation of the unsubscribed shares. Reduction is a completely different situation which we are going to understand under section 66. Okay, and also whenever there's any alteration in the share capital, the registrar has to be informed within 30 days of the alteration by filing form ACH4. and alteration हो रहा है capital में, तो memorandum भी change होगा. Consolidation may affect voting rights because say अभी से 10 shares किसी के पास नहीं है, so उसको पार्टली शेयर मिलेगा. 100 रुपीज का एक शेयर हो गया है, तो इफ समवन डज नॉट हैव 10 शेयर्स ही वुड नॉट गेट वन शेयर ऑफ 100 रुपीज. सो इस सिचुएशन में वोटिंग परसेंटेज जो है, वोटिंग परसेंटेज वुड चेंज. So if there's any change in the voting percentage, so वो calculation, the examples which we have taken बहुत ही basic है. यहाँ पे we'll not know कि voting percentage वगैरह change हो रहा है या नहीं हो रहा है. But however, company के shares कभी भी ऐसे round figures में नहीं दिखेंगे आपको. The capital is always a very huge amount. So in that situation, shares का consolidation may lead to change in voting percentage. And also, any alteration in the capital clause of the company, it must be authorized by the articles of association of the company. मतलब articles of association should give the power to the company to change or alter its capital clause or alter the share capital of the company. समझ में आया section 61? Have you all understood all the different ways in which the share capital of the company is altered? Any doubt in any of the points? So moving on to the next section, section 62. अभी section 62 जो है, it talks about further issue of shares. Now, what is section 62 talking about? Further issue of shares. Let's understand. What are the different means of further issue of shares? Let's understand. सबसे पहले, the company can make a rights issue. We'll understand each and every point in detail. Abhi I'm just giving you an overview. सबसे पहले, company can make a rights issue if it wants to make further issue of shares. या फिर company can issue its shares to its employees. Issue shares here to existing shareholders. Or the company can make preferential allotment. Or could be a situation of conversion of debentures or loan into shares. Then the last point is also on the same lines. It is also about conversion of debentures or loans into shares, but here it is government ke order pe. Okay. So these are the different ways, these are the different means as to how a company can make a further issue of shares. So let's first talk about rights issue. Rights issue में क्या होता है? Can someone tell me what rights issue is? Ever heard of rights issue? Correct. Existing shareholders are given a right to purchase shares at a lower price by the company. So when we talk of rights issue में क्या होता है? कंपनी को पैसे रेज करना है और शेयर्स इशू करना है. तो कंपनी सबसे पहला राइट अपने एग्जिस्टिंग शेयर होल्डर्स को देती है. कंपनी बोलती है आप लोग तो हमारे साथ पहले से हो, सो हम पहले आपके पास आए, वी वांट टू रेज फर्दर मनी, सो वी हैव कम टू यू फर्स्ट बिफोर गोइंग टू द पब्लिक. So first right we'll give it to you. And एक proportion में देती है company ये right. Say 1:2 या फिर 1:5 या फिर 2:5, depending on the company. There's a proportion in which right is given. 1:2 का मतलब क्या? If you have 2 shares, we give you a right to purchase 1 share at this predetermined price. या फिर 1:5 मतलब if you have 5 shares, we give you 1 more share. We give you a right to purchase 1 share at so and so price, which is lower than the market price. So इस situation में company on a proportionate basis gives a right to its existing shareholders to purchase its shares. So say आप किसी कंपनी में शेयर होल्डर हो और आपको ये राइट्स इशू का राइट मिला. You've got this right to purchase the shares in the company. And now as a shareholder, 3 things can be done by the shareholder. There are 3 options which the shareholder has in this situation. What are they? या तो आप accept कर लोगे. You will accept the offer which is being made by the company. या फिर आप decline कर दोगे. और एक और ऑप्शन होता है in case of right shares, and that is renounce your right. Renounce का मतलब I give my right to someone else. I have the right, but I do not want to exercise it, but rather I give it to someone else. That is called as renouncing of rights, and that is possible only in case of rights issue. कोई और issue के case में renouncing of rights is not allowed. Okay, so rights issue के case में renouncing is allowed. So what is happening here? What is the first way of a company issuing further shares? So the persons who are already its shareholders, company उनको in proportion to their holding is giving a right to purchase the security. So company सबको एक offer letter भेज रहा है, letter of offer भेज रही है to all the existing shareholders, stating the ratio, stating the proportion in which the company is offering them the right shares, and also the price at which the share is being offered to the company. अभी जब company offer letter भेज रही है, offer letter shall contain a few details. What are they? उसमें स्पेसिफाई करना चाहिए कितने शेयर्स ऑफर कर रहे हैं और कितने टाइम तक ये ऑफर ओपन रहेगा. आई एम श्योर स्टैंडिंग ऑफर आपको पता होगा क्या होता है. व्हाट इज अ स्टैंडिंग ऑफर? फाउंडेशन में ये पढ़ा है स्टैंडिंग ऑफर.
Ma'am, it is open for the public, ma'am.
It is open to the public, correct, but there's something more to it. So it is open to public at large, that is correct, but it is open for a specified period of time.
Yeah, yes, ma'am. Yes.
Standing offer is an offer which is open to public, but it is open for a specified period of time. So similarly, जब हम when we are talking of an offer of rights issue, तो उसमें क्या होता है? In that situation as well, the offer is open, but it is not that offer lifetime के लिए open रहेगा. आपको जब accept करना है आप तब accept करो. So minimum time जो देते हैं for rights issue is 15 days. The offer should be open for at least 15 days. Maximum time is 30 days. Not less than 15 days and not more than 30 days. So the offer which is made shall limit the time not being less than 15 days, and the time span should not exceed 30 days from the date of offer, within which the offer आप अगर एक्सेप्ट कर रहे हो तो ठीक है, बट अगर आप ऑफर एक्सेप्ट नहीं कर रहे हो तो इसका मतलब ये है कि आपने ऑफर डिक्लाइन कर दिया. एंड ऑल्सो इफ यू हैव नॉट रिनाउंस्ड योर राइट, so we'll assume that you have declined the offer. So this offer of right shares will be open for a certain time span. It is not that वो full time के लिए open रहेगा, नहीं. मिनिमम 15 days, मैक्सिमम 30 days के लिए ये जो ऑफर है राइट्स इशू का वो ओपन रहेगा. ये पॉइंट समझ में आया? However, ये जो टाइम लिमिट है ना 15 days और 30 days का, this time span can be reduced in case of a private company. When? If 90% of the members of the private company, they give their consent in writing or via electronic mode, then in that situation, the time span lesser than 15 days or 30 days would be allowed. So private company case में lesser time span would be allowed, provided that 90% of the members of the private company, they give their consent in writing. प्राइवेट कंपनी के केस में, पब्लिक कंपनी के केस में नहीं. ठीक है. So your time span can be less than this time which has been specified in case of a private company, provided that 90% of the members of the private company, they have given their consent in writing or via or through any electronic mode. अभी इसके अलावा राइट टू रिनाउंस जो है वो भी दिया जाना चाहिए राइट शेयर्स के इसमें. इफ द आर्टिकल्स ऑफ द कंपनी क्लियरली स्टेट कि दिस कंपनी विच एवर राइट्स इशू दिस कंपनी इज डूइंग, उसमें राइट टू रिनाउंस नहीं होगा, दैट इज अ डिफरेंट केस. बट इफ द आर्टिकल्स ऑफ द कंपनी आर साइलेंट अबाउट इट, तो फिर ये जो ऑफर किया जा रहा है, राइट्स ऑफर किया जा रहा है, इट इज डीम्ड दैट देयर इज अ राइट टू रिनाउंस शेयर्स which the person has. जिसको भी ऑफर किया जा रहा है उसके पास एक राइट है to renounce the shares, to give the shares to someone else, to give his right to someone else. So let's now have a look at rights issue.
Ma'am, once can you tell that 15 to 30 days point again, like 90% you told. 15 to 30.
So I told you that the offer should be open for minimum 15 days and maximum 30 days. However, this time span of 30 days and 15 days can be reduced if in case of a private company, if 90% of the members of that company, they give their consent in writing.
Okay. Then the company may decide that between 15 to 30 days, in which case the
can
offer
be
should
lesser
be.
than 15 to 30, 15 and 30 days as well, if 90% of the members, they give their consent in a private company.
Okay.
Okay. So when we talk of rights issue, it involves preemptive subscription rights. Preemptive का मतलब होता है giving a right to someone before someone else or before others to buy additional securities in a company which is offered to the existing shareholders. अभी rights issue से related rules क्या है? So existing equity shareholders उनको एक proportion में मिलेगा. They have to be given a notice specifying the number of shares which are offered and validity of the offer, what is the time span for which the offer will remain open. So validity should not be less than 15 days or such lesser number of days as may be prescribed, but not exceeding 30 days. So minimum 15 days, maximum 30 days from the date of the offer. If not exercised within this time, it shall be deemed that the offer has been declined. मतलब अगर ये जो time span है जिस time के लिए ऑफर खुला है, say for example rights offer is open for 20 days, ऐसा लिखा हुआ है, validity of offer, it has been clearly stated in the offer letter. So within these 20 days, the shareholder, they'll have to either accept or renounce their right. If they are not doing any such thing, it will be assumed that you have declined the offer. अगर आप कुछ नहीं कर रहे हो, if you're not exercising your right within the time span, within the validity period, then the offer shall be deemed to be declined. And the offer shall include a right to renounce the shares to him in favor of any other person unless prohibited by AOA. So if there's a specific prohibition in articles, तो फिर renouncing का right नहीं रहेगा. But articles में कोई specific prohibition नहीं है on renouncing of rights. तो situation में the offer which is being made, it should include a right to renounce which the person has. And if the right to purchase shares is not exercised nor renounced by the members within the time, the board of directors may dispose of the shares in such manner which is not disadvantageous to the shareholders in the company. So अगर renounce भी नहीं किया है, accept भी नहीं किया है within the time which has been specified, तो उस situation में board of directors decide करेंगे कि उनको क्या करना है. They will dispose of the shares in a manner which is not disadvantageous to the company, मतलब which is basically in favor of the company. कंपनी के हित के लिए जो भी होगा, कंपनी के फेवर में जो भी होगा, the board of directors will take that decision and they'll dispose of the shares in that manner, which is advantageous for the company as well as the shareholders of the company. So these are the provisions with regard to rights issue which is made. ये समझ में आया? Rights issue, is rights issue clear? The last point says that in a situation wherein the person he is neither accepted the rights offer nor he is renounced, एक्सेप्ट भी नहीं किया, रिनाउंस भी नहीं किया राइट, तो शेयर्स तो कंपनी ने इशू ऑफर किए थे, तो उन शेयर्स का क्या होगा? वो शेयर्स को डिस्पोज ऑफ करना पड़ेगा. सो द बोर्ड ऑफ डायरेक्टर्स दे विल डिस्पोज ऑफ द शेयर्स इन एनी मैनर व्हिच इज इन फेवर ऑफ द कंपनी व्हिच इज नॉट डिसएडवांटेजेस टू द कंपनी. मतलब कंपनी के बेनिफिट के लिए जैसे भी उनको डिस्पोज ऑफ करना होगा वो वैसे डिस्पोज करेंगे उन शेयर्स को. Here now, yes, they can sell it to others or they can cancel the shares if they want to. If they think canceling the shares is required, they'll cancel the shares. The other way was issue of shares to employee. So when we talk of issue of shares to employee, we talk of employee stock option plans. Now ESOPs क्यों दिए जाते हैं, या what is the reason behind a company issuing an employee stock option plan or giving employee an option to purchase its shares? So when we talk of ESOPs, क्या होता है ना, say there's a person, Mr. Rohit, and Rohit changes his job very frequently. Say एक जगह 6 महीना काम किया, फिर छोड़ दिया, फिर दूसरी जगह 7 months, he worked for 7 months, leaves that job, other place he works for 5 months, leaves that job. अभी ऐसे सिचुएशन में ना कंपनी को बहुत प्रॉब्लम होता है. Now why companies face problem? See, 1 year का time span is usually wherein the company is training you, you are learning different things, और कंपनी आपको ट्रेन कर रही है, और उस टाइम स्पैन में ही आप कंपनी छोड़ के जा रहे हो, तो फिर कंपनी को तो नुकसान हो जाएगा. कंपनी ने इतना टाइम इन्वेस्ट किया आप पे, कंपनी ट्रेन्ड यू फॉर सो लॉन्ग एंड यू लेफ्ट द कंपनी. So ऐसे सिचुएशन में the company would want to hold on to its employees for a longer time span, ताकि ट्रेनिंग होने के बाद भी the employee sticks with the company and stays with the company for a longer time span. So उस सिचुएशन में the company issues employee stock options, issues stock options to its employees. Now say for example 1st of April 2018 को company issued an employee stock option, and it says that if you continue with us for the next 3 years, this 18, 19, 19, 20, 21, 22, अगर आप 3 साल तक हमारे साथ कंटिन्यू करते हो तो 3 साल के बाद हम आपको राइट देंगे हमारे शेयर्स को परचेज करने का एट अ डिस्काउंटेड प्राइस, एट अ वेरी लेस प्राइस, एट अ प्री डिटरमाइंड प्राइस which is very less than the market price. Say market price of the share of this company is 160, but company ये shares आपको दे रहा है सिर्फ 50 रुपए में. Not a bad deal. You're getting share of a company which is worth 160 in the market for only 50 rupees. But ये राइट आपको कब मिलेगा? ये राइट आपको तब मिलेगा जब आप 3 साल कंप्लीट कर लोगे यहाँ पे, not before that. And this time span is called as vesting period. ठीक है, तो यहाँ पे क्या हो रहा है, कंपनी wants to retain the employees with themselves, so company it issues employee stock options to its employee, and there's a separate vesting period which depends on the type of shares which the company is issuing. Vesting period should not be less than 1 year. कम से कम minimum vesting period has to be 1 year, could be 2 years, 3 years, 4 years, depending on company to company, situation to situation. And the person he'll get the right to purchase the share only after the end of the vesting period. उसके बाद ही, यहाँ पे जब vesting period end होगा 3 साल बाद, तब उसको right मिलेगा to purchase the shares of the company. उसके पहले वो purchase नहीं कर सकता. समझ में आई है ESOP का सिनेरियो कैसा होता है? So what is happening here? The company is giving an option. It can either be given to its directors, employees, or any officers of the company. It is giving an option to these people to subscribe to the shares of the company at a future date at a predetermined price. Price हम आज ही डिसाइड कर लेंगे. हम प्राइस ना इसी दिन बता देंगे आपको कि आपको 3 साल बाद शेयर कौन से प्राइस पे मिलने वाला है. We'll tell the price to you. We'll announce the price today itself. However, you will have to comply with all the conditions. सारे conditions जो है वो आपको comply. आपको 3 साल तक हमारे साथ बने रहना पड़ेगा, तभी आप वो option exercise कर पाओगे. उसके पहले नहीं. So employee stock option is basically an option which is given by the company to its directors, officers, or employee to purchase or subscribe to the shares of the company or its company at a future date at a predetermined price. पहले से ही determine किया होगा price और उस price पे हम आपको shares issue करेंगे. Now ESOPs issue करने के लिए company has to be authorized by a special resolution. However, this can be authorized by an ordinary resolution in case of a private company, provided that this private company has not made any default in filing of financial statements and annual return. Special resolution लगता है ESOP के लिए. However, अगर private company है which is not made any default in filing its financial statements and annual returns, then they can instead of special resolution, ordinary resolution will also work. So what are ESOPs? Employee stock option means the option given to directors, officer, or employee of a company or its holding company or its subsidiary company, which gives such directors, officers, or employees the benefit or right to purchase to or subscribe for the shares of the company at a future date at a predetermined price. So future में मिलेगा आपको वो right, but price आज ही हम decide कर लेंगे. Now what are the conditions? Special resolution to be passed in case of a company. However, private company के case में ordinary resolution, provided that the private company has not made any default in filing financial statements and annual return. And in addition to this, Rule 12 of the company rules shall also be complied with. So let's now have a look at Rule 12 and understand what Rule 12 talks about. So in case of an unlisted company desirous to issue shares under ESOP, to its directors, Rule 12 requires certain conditions to be fulfilled. अगर listed company ESOPs issue कर रही है, they should follow the SEBI regulations. So conditions क्या है Rule 12 में? सबसे पहले तो special resolution pass होना चाहिए. It has to be approved by a special resolution. Specified disclosures shall be made by the company in an explanatory statement, which is annexed to the notice of passing special resolution. So whenever a resolution is passed, उसके पहले एक notice जाता है to all the shareholders. So whatever disclosures are required, what type of disclosures would be required here? Ki, what is the vesting period? How many shares are being offered? What is the price at which the share is being offered? All these details shall be attached to the notice by way of an explanatory statement. And the company granting the ESOP will have the freedom to determine the exercise price. Exercise price matlab the price at which the share will be given to the shareholder. The minimum vesting minimum period of 1 year between grant of options and vesting of options. So this is basically talking of vesting period should be minimum 1 year. हमारे example में 3 years था. Minimum vesting period can be 1 year. The company shall have freedom to specify lock-in period. Lock-in period मतलब वो time span जब जो employee है जिसको ESOP मिला है कितने टाइम के लिए वो शेयर को सेल नहीं कर सकता. So the company has the freedom to decide and determine the lock-in period for the shares which it is offering to its employees. So company खुद determine करेगा कि lock-in period क्या होगा for different shares which are granted. The employee shall not have right to receive any dividend or to vote till shares are issued on exercise of option. So जब तक उस employee को shares issue नहीं हो जाते, allot नहीं हो जाते, तब तक इस employee के पास voting right या right to receive dividend नहीं होगा. So only after shares are actually issued to him, only after he actually exercises his option and shares are issued to him, this employee shall have the voting right and shall have the right to receive dividend. And right shares में हमने देखा था कि right to renounce होता है. But say आप employee हो किसी कंपनी के, से आप Infosys के employee हो, you've got an employee stock option. You cannot give it to someone else. या तो आप exercise करो या फिर decline कर दो, reject कर दो. You cannot give this right to someone else. So the option which is granted, it is not transferable in nature. The option granted to employee shall not be pledged, hypothecated, mortgaged or encumbered. Encumbered मतलब कोई charge नहीं create होना चाहिए in this option on any manner. And no person other than employee to whom the option is granted shall be entitled to exercise the option. सिर्फ जिसको option grant किया है, if you are an employee of Infosys, you have the right to exercise this option. If you are not an employee, आपके बदले कोई और इस option को exercise नहीं कर सकता. However, in case of death of the employee, the legal heirs or the nominees, they shall have a right. So in the event of death of the employee, while in employment, all options granted to him till such date shall vest in the legal heirs or employees. So अगर death हो जाती है employee की while he is in employment, तो उसके legal heirs को या फिर nominees को ये जो option है वो उसको मिल जाएगा. And in case employee suffers a permanent incapacitation, all the option granted shall vest in him on that day. Now say for example, okay, so यहाँ पे ना क्या हुआ, the person was in employment of the company but he becomes permanently disabled on this date. तो इस डेट पे जहां पे वो परमानेंटली इनकैपेसिटेटेड हो गया ना, उसी डेट पे वो सारे ऑप्शंस जो थे उसके हाथ में, दे शैल वेस्ट ऑन हिम. मतलब उसी दिन उसको राइट मिल जाएगा ऑन ऑल द ऑप्शंस which were granted to him. This is wherein the employee he becomes permanently incapacitated. So all the options which are granted to him shall vest on the date on which he becomes permanently incapacitated. And अगर कोई terminate कर देता है employment, मतलब he या तो resign कर दिया या फिर termination हो गया, so all options not vested in the employee on that day shall expire. So जो भी option दिया होगा उसको वो expire हो जाएगा since he is terminated. And the options which are vested within the period specified in this behalf can be exercised by the employee subject to terms and conditions under the scheme. मतलब say for example, stock option grant हुआ 1/4/18 को, 2 years was the vesting period and this was the date जब options vest होते. Another stock option was granted on 1/4/19 and इसका period was 3 years. So Mr. Ramesh was an employee of the company and 1/4/8 को भी option grant हुआ था उसको, 1/4/19 को भी option grant हुआ था. He stayed as an employee और 1/4/8 को जो option थे they'll vest here मतलब यहाँ पे now he gets the right to purchase and he has exercised those options. However, he resigns from the company in say August 22. Say August 21 he resigns from the company. तो ये जो ऑप्शंस ग्रांट हुए थे ऑन 1/4/19 उनका पीरियड तो खत्म नहीं हुआ है, बीच में ही रिजाइन कर लिया. तो यहाँ पे जो भी ऑप्शंस थे उसके पास, these shall expire, these shall lapse. बट दीज ऑप्शंस विच ही इज ऑलरेडी ग्रांटेड विद, जो उसके पास ऑलरेडी है, तो उसका कुछ नहीं होगा. द एम्प्लॉई स्टिल हैज अ राइट ऑन दोज ऑप्शंस विच हैव बीन ग्रांटेड टू हिम and those options can be exercised by him subject to certain terms and conditions. कुछ lock in period होगा या फिर कुछ और terms and conditions रहेगा under the scheme which the employee will have to follow. So this was with respect to rules with regard to issue of employee stock options. ये समझ में आया? Is ESOP clear? ESOP is something wherein most people get confused. ESOP hota kya hai? Why is this issued? Yeah, how is this issued? We'll do preferential allotment today. और जो लास्ट वाला है डिबेंचर्स एंड इनटू स्टॉक वो कल करेंगे. Done? Any questions? Can I start with preferential allotment? So preferential allotment, the name itself suggests कि यहाँ पे कुछ type का preference दिया जा रहा है. There's some preference which is being given when we are talking of preferential allotment. So it is basically issue of shares or other securities by a company to any selected person or a group of persons, whether or not they are existing shareholders or employees of the company on a preferential basis. So it is not necessary when we are talking of preferential allotment कि वो employee को ही किया जा रहा है या फिर existing shareholders को ही किया जा रहा है. It can be any person. It is kind of similar to private placement जहाँ पे a selected group of people are approached and they are offered the shares of the company. So preferential allotment क्यों बोलते हैं इसको? The reason is simple because these people are being given preference over the other people. It could be employees or the other shareholders. So the company is authorized to issue to persons other than its existing shareholders and to employees under ESOP. And the issue of those shares is covered under 42, that is private placement. So जैसा section 42 में we have understood what private placement is. Private placement is basically a selected group of people को company approach करती है for the purpose of purchase of its securities. So similarly, when we talk of preferential allotment, a selected group of people is approached, can be other than existing shareholders and employees. एक किसी specific group को आप approach कर रहे हो, आप उनको right दे रहे हो to purchase the shares of your company. Now, this should also be authorized by a special resolution. This issue can either be in cash or for consideration other than cash. Cash में हो सकता है या फिर consideration other than cash में हो सकता है. So when we talk of preferential allotment, it is basically an allotment which is made to a selected group of people other than the existing shareholder or employees. They may or may not include the existing shareholder or employees of the company. The issue can either be for cash or for consideration other than cash, but एक selected group of people को पहले preference दिया है for the purchase of company's shares. So that type of allotment is referred to as preferential allotment. It should be authorized by a special resolution. And also ये सारे जो notice है, the notice of rights issue, it can be dispatched through registered post, speed post, electronic mode, courier, or any other mode to all the existing shareholders at least 3 days before the opening of the issue. So before opening of the issue, at least 3 दिन पहले ये notice चला जाना चाहिए to all the existing shareholders of the company. Are you all clear with the rights issue, ESOPs, and preferential allotment? Any question or any confusion in any of these three? अभी नाउ एक और पॉइंट है इसमें जो मैंने आपको बताया था, conversion of debentures or loans into shares, and then the other is conversion of debentures or loans into shares on the order of the government. We'll start with this tomorrow. We'll not do it today because both the things are interrelated. Apart from this, what else is left in the chapter? So there's section 63, which talks about issue of bonus shares. Another very important section is section 66, which talks about reduction in share capital. बहुत ज़्यादा important section है ये वाला, which we are going to cover tomorrow. After which we are going to cover buyback, section 68, जो है, which is again a very important section. So buyback का concept, reduction in share capital का concept, bonus issue का concept. All of these are very relevant, and all of these are also very important from examination perspective as well. And apart from it, उसके बाद we'll be left with debentures. What are debentures and what are the rules with respect to debentures? So we'll try and complete it by tomorrow. But अगर नहीं होता है, so we'll take one more day, that is 10th. And 10th तक तो हम complete कर ही देंगे, because there are a few things in debentures जो आप लोगों को पता होनी चाहिए. So that will go on for a longer time. And also,
Ma'am,
yes.
ma'am, you told about personation of shareholder, no, ma'am, section 57.
हाँ.
You told, no, ma'am, he cheats, he represents another person.
Hmm.
So in that, they wrote 2 points, no, ma'am. He is the owner of the security or owner of the share warrant.
He represents to be the owner of
Yes,
security.
ma'am.
हाँ.
What is the major difference between share and share warrant?
Just a minute. Your voice was not clear. Could you please type in your doubt?
No, also it is not clear, ma'am.
It is breaking. I don't know if there's network problem from my side or your side.
No, ma'am, you are able to listen.
Ma'am,
Yes.
now you are able to listen.
Now it is fine. Yes.
Ma'am, what is the difference between the security share and share warrant, ma'am?
Share is basically like we've understood, it is a unit in the capital of the company. Share warrants, they were issued earlier. अभी के केस में share warrants नहीं होते हैं, but share warrant is basically an instrument जो ना specify करता है that the person whose name is mentioned in this instrument, he has the title to the shares, या फिर he is entitled to the shares which are mentioned in the instrument. It is just like a, जैसे bearer check होता है ना, वैसे bearer document होता है share warrant.
Ma'am, like share certificate you are telling?
No, it is not share certificate. Share certificate is different. Share certificate is basically a proper document जो आपका authorization बताता है. Your owner, it shows your ownership. However, when we talk of share warrant is a bearer instrument. मतलब you deliver it to someone and by it is how do I explain? 1 minute. It basically shows that the person who is holding the instrument. Say if I have a share warrant, it means that whatever shares are mentioned in that share warrant, I'm entitled to it.
Ma'am, but then there is no difference between share certificate and share warrant, no?
There is a difference. There is
Also, like share certificate also tells that you are the owner of that particular share. It mentions the details.
but this is a bearer document. No, this is not क्या बोलते हैं? This is not, it does not indicate about the possession. It is only a bearer document when we talk of a share warrant. When we talk of a share certificate, it is a legal document which shows that whoever has the possession, he is the shareholder of the company. However, when we talk of a share warrant, it is a document which indicates कि जो भी bearer है of the share warrant, he is entitled to the shares. He does not have the shares, but he is entitled to those shares. Share warrants are basically issued by public companies only, and they are also not compulsory. पहले issue होते थे, अभी issue नहीं होते. If I talk of share warrant, it is a negotiable instrument. However, a share certificate is not a negotiable instrument. When we say negotiable instrument है तो आप उसको ट्रांसफर कर सकते हो. शेयर सर्टिफिकेट को you cannot transfer.
Yes, ma'am. And ma'am, and they told about coupon also, no, ma'am? Share warrant or coupon issued?
Coupon could be bond.
Okay, okay. Ma'am, but the bond will be covered in the security also, no, ma'am? They mentioned it like differently. Why?
So there are sometimes no specific reason as to why a thing has been mentioned separately as well. Coupon could be any other interest or any bond or other type of security of the company.
Okay, ma'am, and in section 59, rectification of register of members, ma'am. In that point, appeal by the aggrieved person, that point is there, no, ma'am? They told if it is entered in the register of members, like he is not the, like you told, no, no, ma'am. If it is omitted to be entered,
Someone's
and
name was entered, but it was later omitted. Matlab, I say I purchased shares in a company.
okay,
I was a member in the company. My name was also entered in the register of members, but later on they removed my name without any reason. I'm still the member, but they removed my name. So it was later on omitted. Uska matlab,
ma'am, they told if the name of the person without sufficient cause entered in the register of members.
it could either, see, there are 3 situations which are covered under section 59. First situation tha, without any reason, someone's name has been entered in the register of member. Matlab, I'm not the member of the company, but still my name has been entered in the register of member.
Okay, understand.
Reason, my name has been entered. Second
Yes.
situation was, I am the member, but my name has been omitted. It was first entered, but then it was removed.
Okay. Yeah, understood. Ma'am, and ma'am, you told, no, ma'am, the like in alteration of share capital, you told about consolidation and subdivision of shares, no, ma'am. Like it will not increase the voting power, or like you told, no, ma'am.
May or may not increase. It is not necessary that it will increase. It may or may not increase.
Yeah, you told, no, ma'am. If we apply for tribunal, then it may increase, or
If there is any increase, then you have to apply to the tribunal.
okay,
So
it
when
is the
the
company's.
company is contemplating consolidation, the company will have to first ensure कि क्या change हो रहा है, what will be the impact. And only after that, if the company is consolidating, so they'll have to take, if there's any change in the voting percentage, so they'll have to take approval from the tribunal.
But ma'am, normally if the shares are increasing, like, or decreasing,
Shares are
the
not
voting.
increasing or decreasing. It is only you are getting proportionate shares. Abhi share ka value has changed.
Yeah, ma'am. Share price has changed.
The nominal value has changed.
Yeah, understood. Ma'am, and you told, no, ma'am, cancellation is different from reduction of share capital. So why it is like?
You will
But
understand this tomorrow when we do section 66. We'll compare both the sections and understand. When we
okay,
do
ma'am.
reduction, there's an actual reduction. Cancellation mein there's no reduction which is happening.
Okay. Ma'am, and this is the last doubt, ma'am. Like in case of right shares or bonus shares, like the shares will increase, no, ma'am. like in case of bonus shares. But like it will not increase the authorized share capital, or it will increase, like
It is
it
within
is
the
the
limit of
maximum.
authorized share capital. No. See, whenever a company is making any issue, company will make an issue of shares only when it is within the limit of authorized share capital. Company cannot go beyond its authorized share capital. If they are making an issue which is going beyond its authorized share capital, they'll first have to increase their authorized share capital and then make an issue.
Okay. And for increasing the authorized capital against ordinary resolution.
Right.
Yeah, understood. Thanks.
Any other question, anyone? और कोई डाउट है किसी को? Any other question? So tomorrow is again going to be a very important class because we are going to discuss about reduction and capital. Reduction and share capital is one very, very important section. Apart from it, we are also going to discuss about buyback and bonus issues. Bonus का तो छोटा सा section है, but buyback and reduction again are two very, very important concepts which we are going to cover tomorrow. So please do not miss the session tomorrow. Do revise whatever we have done today, and please do join on time so that we can start the class on time. Okay, so have a good day. Thank you.